right, everybody. Welcome to week 6, preparing financial statements and affidavits in provincial court. So tonight, our guest speaker is Nicole Villarreal, and I'm Jennifer B. Okay, so we'll do our territorial acknowledgement. So we would like to acknowledge that we are on traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. So again, our weekly reminder about AC Friends of Court. So we're a nonprofit organization that began in 2011. The first legal forms workshop was held at the Access Justice Center located at 800 Hornby Street, which is in the Provincial Court building. Our legal forms workshops helps British Columbians access affordable legal help for a variety of areas of law. At present, we approximately have 45% of our clients are family law clients, and the AC Family Law School is the first program of its kind in BC. Just take a reminder to thank and acknowledge some of our contributors. So we have Kylene Wong of Black Groper, Don Batista, our Executive Director of AC Friends of Court, Dana Cornwell and Andrew Pillier of the National Self-Represented Litigants Project. Without these people and their contribution, we wouldn't have our school today. So again, a friendly reminder about legal advice and legal information. These sessions are for legal information only. We do not give any legal advice. We don't answer questions that are strictly related to your case. So again, what legal advice is when it's strictly related to your case. So if you're asking questions about something that's happened to you in your provincial court matter, we cannot answer it. We can only give legal information, so just standard information only. What document to use to start an application? What document to use to file a financial statement? So for housekeeping, all sessions will be recorded and emailed to registrants. So we're now going to be sending the next lot of recordings towards the end of our course. So that's around December 3rd. We remind everyone that the recordings and reference materials are not to be redistributed, and we thank you for your cooperation. Please, for anyone who hasn't yet, and I think everyone has already, send in your participation agreements. Ensure that your mic is mute and that your video is turned off. Put all questions in the chat box. So the chat box is now linked to me, so I'll be monitoring the chat box throughout our sessions tonight, or throughout tonight's session. Please try to keep details of your case private. So if you have a question, try to keep it towards legal information only, and be respectful when communicating. And any questions that you did not ask tonight or from previous sessions and you just remember now to ask those questions, you can email us at info@litigantschoolbc.com. Please be respectful of speakers, AC volunteers, staff, and other registrants. A reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individual who engages in behavior that the course facilitators determine to be disruptive, abusive, or harassing. So about our guest speaker tonight, we have Nicole from Intra Law Corporation. Nicole practices exclusively in family law and child protection since 2012. Nicole regularly appears in provincial and Supreme Court. She's traveled extensively throughout BC for court since 2012. She was formerly duty counsel for provincial court circuit courts, which was Bella Bella, Bella Coola, and Plemtu. All right, Nicole, take it away.
Thank you so much, Jennifer. Thanks for that introduction. I just want to make sure you can hear my mic okay and everything's fine. Okay. Thank you everyone for being here. we're discussing a very important topic today, financial statements and affidavits. These are two really important documents that are used regularly in provincial court. And the contents of each document can really have a significant impact on your case. So I commend all of you for being here to learn more about these topics. I hope you're going to find it helpful and informative. As usual, at the end, we will save time for questions and answers. I might also check in maybe halfway through the presentation to see if people do have questions. So if you do, as Jennifer said, please put them in the chat or make a note of them to ask at the end. Okay, next slide, please. Okay, so we're going to start with the financial statement, Form 4. And so throughout the presentation and even in court, you might hear folks using this interchangeably. So when I'm referring to financial statement, the actual document is called Form 4 financial statement. So if you hear both terms, that's what I'm referring to. Okay. Go to the next slide. Thank you. And so what I recommend, you've probably have seen this webpage, but going onto the provincial court website to access the court forms. So this is really important because the forms recently, I don't know exactly how long ago, maybe a couple months ago, were all updated. And so the provincial court website will actually have all of the forms that you will need to file in provincial court. So that includes, your applications to start a court proceeding, and as well the financial statement and affidavits, which we will be discussing later. So I've included a link here. So if you don't want to use this link, or you just are on Google and want to just find the website quickly, what I do is just Provincial Court Family Forms, and the first website that pops up should be this one. And why I recommend using the online forms, not just because it's the most updated, but because they have a PDF like fillable form. And for the financial statements where you're having to put in a lot of numbers, you're having to add in your expenses and your debts, which we'll get into momentarily, it's really nice because the forms will populate summarize the expenses and the debts for you and the income. So it's really nice if you have access to a computer to be able to fill it out on the PDF because of that feature of it being able to calculate it for you. Okay. Okay, so financial statements, when are they required? So there are a couple scenarios when you will have to file a financial statement. So the first one is if you're starting a court application, so filing what's called an application about a family law matter, an F3, or a counter application for special or extraordinary expenses, or Section 7 expenses, or spousal support. So this first scenario under number 1, it's where you're the one starting an application for something. Again, either special or extraordinary expenses. So these are expenses that are in addition to the base child support that someone is going to pay, or spousal support. You'll also be required to file a financial statement if you're filing an F6 reply to an application about a family law matter where the person applying has asked for child support, including Section 7 expenses, and or spousal support. And I have a note here, and it's really important. The rules changed a couple years ago, and there are a lot more requirements and all new forms. And one of the most important, I would say, requirements or new changes is the court registry will not accept your application under number 1 if one of these scenarios applies to you, or your reply under number 2 without a filed financial statement if a financial statement is required in one of these scenarios. And so if, for example, you can't file a financial statement in time and you really need to get the reply filed because the 30 days to file a reply is expiring, then you might have to apply to court for an order, permission to file your financial statement late, or file your reply with your financial statement late. So that's something that even us lawyers have learned the hard way when the new rules came out, is that if you need more time after that 30 days and a financial statement is required, you will need a court order for that extra time. Okay, the next slide, please. Okay, so why are financial statements important? So the court needs financial information of the parties in order to make orders about child support or spousal support. Another reason why they're important, and I think one of the reasons why the court requires it early on, just like I was explaining in my earlier slide, is that sharing this financial information with the other party and receiving that financial information increases the chances that the parties might be able to resolve the financial issues, maybe before court or without having to go to a hearing. So the courts are really encouraging, that early financial disclosure, just to increase that possibility. I also have some notes here about what if a financial statement is not filed despite requirement to file it or a court order to file it. So these are some options for the court at their disposal. Number one, the court may impute income to someone. So they might draw what's called an adverse inference. And so what does that mean? Essentially, if someone is under an obligation to file a financial statement and they fail to, or they provide insufficient information, the court could say, well, based on the evidence before me, from the other side, I'm going to set this person's income at, and then set it at that income, even if they don't have the financial statement or financial proof. So that's what's called imputing income. So it's really important if you don't want that to happen to you, to provide the court with full financial disclosure. The court can also make further disclosure orders. So again, if someone was under a legal obligation to provide that financial statement within 30 days, for example, and doesn't, then the court could make a further order, saying, okay, now they have 2 weeks to provide the financial statement. The court could also require a party to give security. So what that means is the person who's under that obligation to provide a financial statement might have to pay money into court until and won't get that money back until they've provided that financial disclosure. In some extreme situations, perhaps where there have been several orders for financial disclosure that have not been followed, the court could make the other party who's not disclosing pay the other party's expenses, so legal fees, up to $5,000, or fine that person who's not making financial disclosure a fine of up to $5,000. And again, for that to happen, there typically has to be, in my experience at least, breaches of financial disclosure orders, or someone really not cooperating despite, again, their legal obligation to do so, or a series of orders. Okay, the next slide, please. Okay, and we're not going to go over the provincial court family rules in detail, but I just wanted to note them for you here. So the rules that apply to financial statements are rules 3, 25, 28, and 172. So if you're interested in reading those later, you can. I just wanted to note that financial statements are going to include really sensitive financial information of the other party. So they're going to include social insurance numbers, tax information, employer information. And so it's really important to remember that a party cannot use or disclose any information that is contained in the financial statement of the other party, except to the extent necessary to resolve a case under the provincial court rules. And so that's right from the provincial court rules. And that's just an important reminder that because you're receiving sensitive, confidential information, it's only to be used in the court proceedings, not to be shared with any party who is not a party to the case. It can be shared, of course, with your lawyer if you have one, or if there is a mediator who is assisting the parties with mediation. Okay. Okay, so now we're going to get into the nitty-gritty of the financial statements, what you need to attach. And a lot of the next few slides are going to be technical. I have, screenshots of the actual financial statements. So I'm going to ask everyone to bear with me. This is really important, but again, it's very technical, and I hope it's not too dry, but we'll get through it. One slide at a time. So the first part of the financial statement is part 1, section 3. And it tells you basically what you have to attach as proof of your income. So what you attach will depend on your particular situation. So if you are working, if you're employed, you're going to attach a recent pay statement. If you're receiving employment insurance benefits, you're going to attach your EI statement. If you're receiving government assistance, then a recent government assistance statement, pension income statement, if applicable. And then you're also, generally speaking, going to attach your income tax returns and your notices of assessment or reassessment from the Canada Revenue Agency for the last 3 taxation years. So that would be the last 3 taxation years would be 2023, 2022, 2021. And this is if you are a regular salaried employee. Okay, and so I include this because this is generally what is going to be attached to the financial statement. The income tax returns, and I'll speak more about this later, but a lot of time, in my experience, a lot of my clients have a hard time tracking down their income tax returns. They can easily find the notice of assessment because that's what they get back from the Canada Revenue Agency in the mail or by email, and they can access it online. But some of them can't find the income tax returns because they've sent it to the CRA, and the CRA doesn't actually send the income tax returns back. So I'll speak more about this later, but it's a really good practice point that, once you're sending off your taxes to be filed, keep a copy for yourself. If you have an accountant who has helped you prepare your taxes, they might keep a copy for you, but make sure that you do have that because it's a common issue that comes up in a lot of our cases. Like sometimes people will only initially be able to attach the notices of assessment to their financial statement, and then the court will have to make further orders to say, okay, they also have to provide the income tax returns eventually. On the right-hand side of the screen, I also have 2 other scenarios. So if you own a corporation, there are additional requirements for attaching to the financial statement. So if it's applicable, you're going to have to include your corporate income for the 3 most recent taxation years, including financial statements and breakdowns of all salaries and management fees. And if you're self-employed, then you would have to include income again for the 3 most recent taxation years, including financial statements and breakdowns of salaries and management fees. So this is in addition to your personal income tax returns if you have a corporation or are self-employed. Okay. The next slide, please. Thank you. Okay. So another benefit of going on the provincial court website to obtain this financial statement is there's also a guidebook that you can consult for information on how to complete this. But this page right here that I've screenshot is on the actual financial statement. And at the bottom, you'll see this chart, and I hope it's big enough for you to see, but essentially the financial statement has 6 parts, but not all parts need to be completed. It really depends on your situation. By your situation, I mean, what is the current application that you're either making or that you're responding to? So on the bottom of this page, you'll see there are different situations. So I'll just read some of them. There's an application for spousal support. I'm being asked to pay or am paying child support. Parenting time is split or shared. There's a child at or over 19. About a dozen different scenarios. And then it'll tell you with these check marks what parts of the financial statements you have to complete. So let's just say, okay, situation 3, parenting time is split or shared. So what split or shared means, let's just say there are 2 children, one child lives with one parent, the other child lives with the other, that's split parenting, or shared parenting. So shared parenting under the Family Law Act means each parent has the child or children in their care at least 40% of the time. So in that case, you would see that you'd have to complete parts 1, 2, and 3. You'll see the check boxes. So this is really helpful. It's not, I've done some financial statements where we've completed more parts than we'd had to. So for example, if I'm the second scenario, I'm being asked to pay or am paying child support, you only have to complete part 1. Sometimes I'll also complete part 2 and 3. I don't think it hurts to complete more parts than you have to, but definitely if you are required to complete the parts like 1, 2, and 3, you want to make sure you do that at a minimum, because again, the court can make further orders for you to redo or update your financial statement. Okay, and I just have a note here. So read the instructions again to determine what the applicable parts are to complete. And on page 2, that's where you'll find, on page 2 of the actual financial statement is where you will find that chart. All right, so we can move on to the next slide. Okay, so this page, and just gonna refer, this is actually the 4th page of the financial statement. And this is the page we're going to talk about how you actually get the financial statement sworn, filed later on. But I just wanted to show you that this is the signature page that you will eventually sign in front of a commissioner for taking affidavits, or a lawyer or a notary. And I'll provide information how to actually do that. But you're swearing that this financial statement is true to the best of your knowledge, okay? To the best of your information and belief. It has to be accurate. And you'll see on this first page that that's what number 1 says. The information set out in this financial statement is true to the best of my knowledge. And number 2, I've made complete disclosure in this financial statement of, and you'll see all the different parts of parts 1, 2, 3, 4, 5, 6. And so when we think back to that chart that I showed you in the previous slide, you'll know which sections you have to complete and you would check them off. Okay. The main ones that we're going to be focusing on are your income section, part 1, your expenses and debts, part 2, and your assets, part 3. And it's really helpful. Again, the PDF form is great because you'll see on the right-hand side of this form, there are these blurbs. They give you instructions on basically like each section that you'll fill out as you see throughout the financial statement. So it's really helpful. I think since the forms changed, this is really one of the, in addition to the guidebooks, really one of the best, I think, changes. To me, it's very easy to navigate. So yeah, have a look at those blurbs as you're filling the financial statement out. Okay. All right, so we can move on to the next slide. Okay, so income. So this is really a really important part, no matter which situations apply to you. Looking back at that chart, everyone's going to have to fill out part 1 because the court and the other party need to know what your income is to determine child support and or spousal support. And so I have a note here that your total income, the court wants to know, is your income before taxes. Okay, so we call this your gross amount. And this is what child support is based on. Okay, so before the CRA deducts any income tax, provincial or federal income tax, we want to know, like, what is that gross amount? Because that's what we use when we look up the child support owing, and also for spousal support. Okay. I just have here for your own interest later on, once you're actually going through the financial statement, that certain deductions from income are permitted. So I tell you to look at lines 2 to 9 on part 1, page 2 of 2. You can refer to that later. But if, for example, you have union dues, those can be deducted from income. So very specific deductions. If there's some employment expenses like other professional dues, business investment losses, very specific deductions. And again, there's going to be an explanation once you're actually completing that section about what can be deducted. There are also certain additions to your income. some examples might be uh, offset of capital gains and capital losses, like very specific situations that may not apply to you, but you would have a look at all of those potential additions to income as well. And again, what I had mentioned about the PDF calculating everything for you, once you punch in those numbers on the computer, it'll actually calculate the additions and deductions. And I just have a note as well, if spousal support is an issue, so either you're applying for spousal support or being asked to pay, you would have to complete some additional information as well. Okay, so I think we can move on to the next slide. Okay. So what if you anticipate changes to your income? So I tell my clients that the financial statement, you can think of it like a snapshot in time, right? It's not uncommon for people's incomes to change year to year, or even like month to month. And so, what I recommend to my clients, in part one, section 4, there's a section called changes to income, and you have to select on the financial statement one of these two options. So, I do not expect any significant changes to my total income this year, or I expect my total income this year to be blank because, and then provide a short explanation. So, in an example where, let's just say, last year, your notice of assessment said your income was $40,000. But this year you're anticipating it to be $60,000. Well, you might want to explain why there is a difference. Maybe you were laid off for part of last year, or you lost your job for part of the year, or you got a new job this year. So you're not providing like so much detail to the court, because that'll eventually, happen, in court or at a hearing. But if there is something that you want to explain like that, you can add a little blurb in the financial statement, just explaining that discrepancy. Okay. So the next slide, we're going to go on to personal expenses and debts. Okay, so again, I'm taking this right from the financial statement. If you're interested, the reference is page of a financial statement, part 2, page 1 of 2. It just got cut off there on the bottom. I know this looks like a lot of information you need to put in, but it's not actually so bad, like once you start going through it. This gives the court an idea of what your monthly and annual expenses are. So you'll see that they've broken down these categories into housing, food and household supplies, transportation, and then clothing and self-care, health and medical, children, miscellaneous other, premiums, contributions, debt repayment, and then money setting aside to pay income tax. Again, the PDF is going to calculate these amounts for you. So if you put in, your rent every month, it should calculate. I don't know if it calculates the yearly. You might have to multiply that by 12. But once you put all of that information into the two right-hand columns, it will calculate at the very bottom. It'll have a total. It just got cut off there on the slide. What I tell people is to use your best estimates for these expenses, because sometimes you don't incur these expenses every month. So for example, with transportation, maintenance and repairs, you might not have car maintenance expenses every month. That might be once every 6 months. And so you might have to do a little math and estimating. So, you might say, okay, well, in a year, last year, I spent $500 a year in car maintenance. And so you might just have to do some math and say, okay, 500 divided by 12 is $41.66 $6 a month, and then put that in your monthly. What I do with my clients is when they're giving me the numbers for these amounts, I like to have like on a separate piece of paper, just for my own notes, how I got to that number, how I calculated it. So for example, with the car maintenance example, $500 a year, I'll just have for my own notes, okay, I we spent $500 on that last year, so I just divided it by 12 to come up with an average of $41. Just in case there's any question later on about how you came to calculate that. So it's really important. So when I said earlier, these documents that we're filling out, the financial statement, the affidavit, will have a significant impact on your case. I can't stress that enough, especially when we're doing these expenses and debts, because the court and the other party, when they receive your financial statement, they're going to review the expenses. And, sometimes what raises them questions is if someone has like really high expenses, for example, let's just say the annual expenses altogether are $60,000. Okay, but then we look at the previous sections where the income they're declaring is, let's just say, $30,000. That raises some questions about well, how are these expenses being paid, if this person doesn't have a lot of high debts, for example. And so it's really important to answer these questions accurately, and also just keep that in mind that, they're going to be, the courts and the other side are going to be looking at these expenses very carefully. I have a note here about, so just the fourth bullet, as I said, high expenses not supported by income will raise some questions. It also really impacts credibility. So the financial statements are really important documents because, as I showed you on that first page, you're swearing that the contents are true. And so at a hearing, a court hearing or trial, the other side can cross-examine you on these financial statements, and specifically the expenses and the income. So I say that the expenses have to be accurate, because they can also be verified by bank and credit card statements if the court orders it. So, for example, in my scenario where someone has really high expenses not supported by income, the other side might say to the court, well, I'd like to see this person's bank and credit card statements, for the last 3 years to see what they're spending money on and to see if these expenses are accurate. And so in some cases, the court can order that the bank and credit card statements be disclosed, to provide the court with further information. Okay, go on to the next page. Okay, then debts, again, you're only going to complete this section, part 3, if required. But this is just, again, a screen grab of the debt section, and this is going to be a list of your outstanding debts. And so you're going to name the creditor. So this would be the name of the bank or credit card company, or if it's a personal loan, who that person is. And then in the second column, why you borrowed that money. So an example could be, Visa credit card, living expenses is the reason, and then the current balance owing. And again, it's going to calculate for you what the total debts are. One practice point is you don't want to list the monthly payment, because this would be listed under the expenses section under debt repayment. So in the previous slide, we have a section for monthly debt. Premium, yeah, right there. Thank you, Jennifer. Right there. Yeah, exactly. So you're going to put your monthly. So let's just say on the credit card balance you're carrying, you have to pay $100 every month. That's where you would put it on the personal expenses and debt. But on the next slide, so for the actual list of debts, you would put the balance owing. Let's just say the outstanding balance is $2,000. You would put the balance owing in that third column. Okay, and again, I see here that proof of debts might need to be provided to the court. So the court might order that you provide a credit card statement, or if it's a personal loan, you might have to provide a copy of the loan document. So just be aware of that. Okay, move on to the next slide. Okay, so assets was part, let me just refer to my financial statement. Part 3, sorry, expenses and debts. So the previous slide was part 2. So part 3 is assets. So again, you're only going to complete this if required. And here again, they've broken down the assets into different categories. So real estate, cars, boats, vehicles, cash assets, investments, loans, and credit. So this is where someone owes you money. And then other, so personal items such as precious metals, art, jewelry, other items of high value. You're going to include the description in the second column and then the current value. And a practice point, something really important to note is you're going to have to list all the bank accounts that you have in your name. Even if the account is small or zero, the value is zero, you don't use it, it's best to list it because you don't want any questions to come up later on. Like, if the other side finds out you had an account you didn't list and you didn't list it because you don't really use it, you just don't want any adverse inference, meaning you don't want the court or the other side to say, well, why didn't you list it? What else are you hiding? So if you're in doubt, list it. If you hold an account with another person, so such as a family member, like a parent, list it, okay? Even if you're a secondary account holder, it's just best to list it. So I say, if in doubt, list it. You're going to include investments, so again, TFSAs, RRSPs, RESPs, so Registered Education Savings Plans for Children, pensions. For some of these, you might not know the value. So for example, pension, if you have a pension through work, you might not know the current value. And so you could just say unknown if the value is not known. Okay. At the bottom of this page, it has a section disposition of assets. You'll have to let the court know whether or not in the last 2 years you've sold or disposed an asset. So yes or no. And if you have sold or disposed of an asset, you'll have to describe what that asset was and how much money you made from the sale or disposal. Okay, so that's the asset section. We can move on to special or extraordinary expenses, section 7. So you heard me refer to this earlier in the presentation about, when a financial statement would be required, and this would be one of them. So just briefly, and I'm not sure if someone has already presented on child support in general, but just briefly, section 7 or special or extraordinary expenses, and I'm going to use the terms interchangeably. There are expenses that are above and beyond what is covered by the guideline table amount for child support. So these expenses, if a court orders it, are going to be shared in proportion to each party's incomes, meaning each party, based on their incomes, is going to pay a certain percentage. It might be 60-40, 70-30. It depends on what the incomes are. And I've included what some examples might be. And I apologize again if you've already gone over this with someone else, but just for the purposes of our presentation, I think it's good to have a brief overview. Some examples could be childcare, medical or dental premiums attributable to the child, health-related expenses that exceed insurance reimbursement by $100, extraordinary expenses are primary or secondary school or post-secondary school expenses, and sometimes extracurricular activities. Not usually in my experience. It really depends on, what the activity is, how long the child's been doing it, whether they have a real talent for that activity. So that's very fact specific, but generally it's going to be the earlier examples. And then on the financial statement, and we'll show you, actually, I don't have a screen grab of it, but it's a section that you'll have to complete if you're applying for special or extraordinary expenses. Just for your reference, this is part 4. You're going to list the child's name and the annual amounts, net of any subsidies, tax credits, deductions, and contributions of the child. So basically what net of any subsidy means, what are you paying out of pocket? So let's just say for daycare, you're spending $500 a month out of pocket. Let's just say, I'm just throwing out numbers, the daycare is actually $800, but you get a $300 subsidy. So the amount you're going to include on the financial statement is that $500 net amount. I also have a note here that you want to keep proof of how these amounts were calculated. So if you have receipts for what these Section 7 expenses are, you'll want to keep that. They don't necessarily have to be attached to your financial statement, but you will have to provide proof of it in court eventually if you're asking for the other party to contribute to them. So definitely keep copies of those receipts. Okay. All right, we can move on to the next slide. Okay. And then just for your reference, I touched on this earlier, but as I said, you'll have to attach at a minimum the last 3 years of your income tax returns and notices of assessment or reassessment from the Canada Revenue Agency. So I've included a link to the CRA website where you can access or you can create an individual account. And then you should be able to, it sometimes takes a while to get the login credentials, and you might have to link your bank account to it or credit card. But once you're in and you have your login, you should be able to access your notices of assessment or reassessment. But again, what I said earlier about the income tax return, that is separate. So the CRA, they on the website or on their My CRA account, you might be able to get like an income tax summary, but that's not your full tax return. That's not what you actually sent to the CRA. So earlier I had suggested keeping a copy of that for yourself because you will need that for the last 3 years to attach to your financial statement. And on the next page, next slide, I just have a screenshot for what that page should look like. So you'll see that you have an option here to sign into your account if you already have a CRA like online account, or on the right-hand side, register for your account, okay, if you don't already have one. I know it can be, I've had to call the CRA on behalf of clients. I know you could be waiting a while. Sometimes it does take some time, as I said, to register the account. But once you're registered, it's really handy because then you can get all of the documentation other than the full income tax return online. Okay, so I have a couple more slides of the financial statements that we'll just finish up on, and then maybe we'll take a 10-minute break before moving into the affidavits. So on the next slide, I just have some tips about swearing the financial statement and serving them. So the financial statement I mentioned earlier has to be sworn, so signed. You're swearing it's true, declaring it's true before a lawyer or a notary or a commissioner of oaths. Don't sign it beforehand. You actually have to physically sign it before them. When we talked about the attachments, so attaching the income tax returns and the notices of assessment, and your pay statement, for example, all the attachments have to be attached to the financial statement when you're swearing it before the lawyer, notary, or commissioner. You can also have the financial statements sworn at the provincial court registry. They won't charge you, so there's no fee, but you will have to bring 4 copies of it. So your financial statement, all attachments, 4 separate copies, and you'll sign each one before one of the registry staff. But I wanted to bring your attention to Rule 172. So as a practice point, I always say, like, try to get them sworn, especially if you have like a deadline to have this filed. But this is an important rule because if you really can't get it sworn, or you live in a community where it's really hard to get to a lawyer or notary or commissioner, this rule allows an unsworn document to be filed at the registry if you'll be available to swear or affirm at the court appearance that the contents of the document are true. So for example, if you have a court date, in a few weeks, and you need to get this financial statement filed so the court has a copy of it and the other side has a copy of it in advance of the court date, the registry can actually accept an unsworn financial statement, so long as at that court appearance, you will be able to swear at the time. So the judge can ask you, do you swear that the contents of your financial statement are true? This rule should allow you to do that. But again, it's best practice if you can, at all possible, have it filed and sworn in advance of your court date. Okay. And then the last financial statement slide. So if you're filing your financial statement with your application, like you're starting the application again for child support for Section 7 expenses or spousal support, you're going to file the financial statement together with your application because the court registry, as I mentioned, is not going to accept the application without a financial statement. So you're going to file that together. If the financial statement, if you're filing that with a reply, because you're required to file a financial statement with it because someone has applied for child support and or spousal support, the registry is going to be the one to serve a copy of the financial statement and reply on the other party. So they'll typically email or mail a copy of the reply and financial statement to the other party's address for service. In any other situation, the financial statement has to be served by ordinary service. So if it's not one of the two scenarios above, then you're going to serve it by ordinary service to the address for service of the other party. I should note just with respect to the first bullet, so the financial statement, if you're filing it with the application about a family law matter, that has to be served personally. So that the application about a family law matter has to be personally served on the other party. So you're going to be serving that together. If it can't be personally served, you'd have to apply to court for an order allowing you to serve a different way, such as by email. Okay, and I think that brings us to the affidavit. Okay, so this is, I think, a good time for a 10-minute break. We'll come back at just before 6:30, 6:28 to start with affidavits. But if you have any questions that you'd like to ask about financial statements, like while it's all still fresh in our minds, Jennifer, could they just send you a chat and maybe we could just spend a few minutes before getting into the affidavits?
Yeah, we have some questions sent already. So when we come back from the break, we can just quickly get those out of the way.
Great. Okay. Thank you so much. See you
Great.
soon.
Okay, everyone, see you back at 6:28.
Okay.
Okay, so we had a few questions during the financial statement part of the presentation. So I'll start with the first question. So I'm just going to read it for verbatim.
Yep.
If I filed for child support in Section 7, I think this one may have been touched on already. If I file for child support in Section 7, will I have access to both the reply and the financial statement? They ask because the other party did file a reply, but the forms that were sent to this person by the registry did not include a financial statement. Should they reach out to the registry?
Yeah, I think it'd be a good idea to reach out because the person filing the reply under the rules would have had to file a financial statement because of the child support and because of Section 7. So that might have just been inadvertently like missed. So yeah, you can go in person to the registry and even have a look at the court file to see what has been filed. And if for some reason the registry accepted the reply without the financial statement, so there could be other documents like maybe this person filing the reply asked for an order that they file the financial statement late. That's another possibility. And so maybe there is no financial statement. So just finding out what's going on because they could have filed what's called an application for case management order without notice, asking the court to allow the late filing of a reply. And because that application's without notice, you wouldn't have necessarily gotten a copy of that. The court would have just read the application, approved it or not approved it. And then, yeah, the person has extended time to file. So it's a good idea just to check what's happening in the court file and go down to the registry.
Right, perfect. So this one, I think they just kind of want to know the difference between certain terms. So asset, loan, and credit, what does that mean?
Asset, loan, and credit. Okay, so let's just have a look at the actual financial statement. So an asset, just read that on part. So assets would be part 3. So that's where we went over, different examples like real estate, cars, cash assets, basically any kind of property that you have. And when I say property, it doesn't have to be like a house. It doesn't have to be like real property. It could be like a bank account. It could be an investment. I think the question was like loan credit. So on the part 3 assets, there's a section under assets, which I think is confusing, that says loans and credit. But then in brackets, it says money owing to me. So let's just say you loaned a family member $5,000. How the court sees that is actually an asset because it's money owing to you. Eventually, you should be paid for that. So that would be $5,000 to you. And so you would have to add that as an asset. So it is a little confusing, but it does have in brackets money owed to you. And so you could just provide details of that. It's a personal loan. I lent $5,000 to a family friend. These are the loan repayment terms, or there are no loan repayment terms. And then put the total value of what that loan is. So I hope that answers that question, but it is a little confusing.
So for this one, they just want to know when it comes to swearing in the financial statement, if they can do it in a different province, even if it's a BC court case, can they do it in a different province?
Yeah, you should be able to. They'll just have to, whoever's you're needing to swear it. So if it's a lawyer or notary, on that signature page. So I'm gonna just hold it up to the screen. I don't know if this will work, but on that signature page, where you would sign it before the lawyer or notary, the PDF form says sworn or affirm before me at blank. You put in the city, and it has British Columbia, and then the bottom section where the commissioner notary signs right here, it says a commissioner for taking affidavits in British Columbia. So I've had affidavits, where clients swear them in, Alberta, for example. The notary can just cross out British Columbia and put whatever province. And then same with that commissioner part, they can just add that in, but you'll have to just, have that sorted out with whoever you're signing it with in the other province, and then it would be filed in British Columbia. But make sure if you're doing that, keep a copy of the original, because if you're having it filed or sworn in another province, and let's just say you're emailing it to the registry to be filed, and this goes for any document that you're filing at the registry, always keep an original, because you might be required to produce the original later on in court. But especially for financial statements, and especially financial statements and affidavits, and especially if you're having them sworn in a different jurisdiction, you're going to want to make sure that you have the original for your records.
Okay. So for this one, and I can answer part of this question after you answer it. So where can I find a commissioner who can issue an affidavit, or I guess swear in an affidavit for free or at low cost?
Yeah. So my suggestion was going to the registry, the provincial court registry. You'll just have to bring enough copies. So they usually want 4 documents, like 4 separate financial statements, all containing the same information, same attachments. You would bring them, and then you would swear them. And there's no cost to do that. It's free of charge, would be my number 1 suggestion.
And also, if you're in the Lower Mainland, AC Friends of Court, through their legal forms workshops, they do offer free swearing in of affidavits and financial statements. So normally it's around the last week of each month. So they have in-person workshop at 312 Main, another in-person workshop in Surrey, and another one in Richmond. I can locate those actual areas for you, or you can also, if you go to email helpme@legalformsbc.ca and ask about that, they should be able to answer and tell you, where they typically have the in-person workshops, and then you can go there for free.
That's great to know.
Yeah, they started doing that within I would say within the last couple of years, and especially like now that we're can have things in person again. So they started offering that in our in-person workshop. So because obviously online it's not always the
Yeah,
easiest to
right.
do.
Yeah.
So financial statement based on. Okay, financial statement based on last income tax return filed or another period has to be submitted. So I guess they want to know like what's the appropriate amount for, I guess, disclosing your income?
Good question. So on the income section, let's see. Okay, income summary. Okay, so there's a helpful blurb. I didn't go over this, but on, so this is just for your reference, financial statement part 1, page 2 of 2, where you're adding in like my total income. I'm so sorry, but it says my total income. There's a blurb and I'll just read it out to you. Um, if your income and adjustments are expected to be similar to your most recent federal income tax return, you can use those amounts for the annual income summary. If not, record what you expect the amounts to be. So earlier when I had mentioned, if you expect changes to your income this year from last year, you can include a blurb on the previous page under changes to income if you expect significant changes to your total income this year and the reason why. But typically, and this is not giving advice, but what the financial statement requires is that you use your last year's income tax return, your line 150 generally, if your income is pretty consistent year to year. But again, and it says that right there, if you expect your income this year to be similar to your last year's income, use that last year's income. But if you know, for example, that, okay, I've changed jobs or I'm on commission. Last year was a really like low year for me, but I'm projected to earn much higher. Or, you're throwing your financial statement towards the end of the year when you know more or less what you've earned already for 2024. You can use the current amount, but just have an explanation there. So again, I think the best spot to put that is under that changes to income. And just be clear, like if you're using line 150 income from last year's 2023 notice of assessment, that you're indicating it. And again, just have as much explanation as possible for why there's that discrepancy, but also for your own notes. Like if you have to explain, why you use this income as opposed to the last year's income, that you can easily explain that to the court.
So happy they have that explanation part
Oh,
back
yes.
because for a while there they didn't have it, and you're like,
Yeah, and so we had to get creative, like for my clients, like, we would sometimes uh, edit the PDF to add like a little blurb, like, okay, this is my income last year, but this year, this is what's happened, or I've lost my job, or I'm not working, but I plan to return to work. It doesn't have to be a long explanation, but, and I think on the PDF, they only give you 2 lines. Where you say, I expect my total income this year to be blank because, and it's literally 2 lines. So you're not adding, paragraphs and paragraphs. So just a short explanation about how you came up with this income and if there is a difference from last year's income, why.
all right, so that's it for the financial statement side. All right, let's continue on.
Okay, all right, affidavit. So another really important document in provincial court. A lot of the same considerations will apply about credibility and the having a significant impact on your case. So I'll go over that momentarily, but an affidavit, a general affidavit is called Form 45. I won't really call it that during the presentation, but if you want to locate the form, I've included what it is, Form 45. And again, I've added the provincial court website link to access the affidavit PDF. Essentially, what an affidavit is, it's a fancy word for a document that contains facts you swear are true under oath. Okay. The applicable rules, just for your reference, if you want to have a look at them later, are Provincial Court Family Rules 172, 171 and 172. And on the next slide, I have what the form looks like when you go onto the provincial court website and download Form 45. So you'll see here on the top right corner, you'll have to include the registry location, the court file number, and then the list of the names of the parties. And then you're gonna have your full name as it is in the court file, your occupation and your address. And again, just like the financial statement, you are swearing or affirming that the following facts are true. And there's an important sentence here following that. If these facts are based on information from others, I believe that information to be true. And we're going to talk about what that means later on. But this is basically you confirming that everything that you're saying in your affidavit, to the best of your knowledge, is true. You're also going to say, number one here, I'm making this affidavit in support of an application, and you're briefly going to describe the application, or in response to an application and briefly describe the application. So an example could be, I'm making this affidavit in support of an application to increase my parenting time with my child. Or I'm making this affidavit in response to an application to decrease my parenting time with a child. So you're just briefly, and they don't give you very much room, in a few words, say what your application, or sorry, what your affidavit is in support of. Now, you'll see that the number, so 2, 3, and 4 are where you're going to fill in your the facts, and you're going to say, well, this is not enough room for all the things I want to say. So what I do is I attach additional pages. So if you have access to a computer, you can use like a Word document and attach the written, like the document, or sorry, the pages to your affidavit. But it's important, I would say, to use this first page because it has all of the information that you're going to want to put in your affidavit. It's already formatted. So I just attach, extra pages to the affidavit. And then similar to the financial statement, you're going to see this signature page. Now, because this signature page, or sorry, it's called a jurat. This should actually go at the end of the affidavit. So if you're attaching additional pages, you might want to actually just type up and, if you're having someone swear this, maybe they can assist you in putting that jurat, the signature lines, on the last page of your affidavit, just because we want to make sure that everything that you're swearing and filing in court is what you actually signed in front of that commissioner or notary or lawyer, right? We don't want there to be any mix up or confusion that maybe some pages, additional pages that were attached, weren't actually part of the whole affidavit that was sworn. Okay, so that's just important. I just don't know if you can add in the PDFs to. What I do is just adding in the Microsoft Word documents and then having that signature page at the very end. But yeah, so I think it's still important to use the PDF because it has everything that you need at the beginning. If you're savvy with the Word document, you can also just copy and type out everything that appears on this PDF onto a Word document and do it that way. Okay, so we'll go on to the next slide, please. Okay. So when are affidavits used? So they can be filed in support of an application or reply, like we saw in the earlier slide. So an application about a family law matter. So if you're applying for parenting arrangements or child support or spousal support, guardianship, contact time, they can be filed in support of an application about enforcement. So if you are applying to or responding to an application about enforcing a court order or agreement, you can file an affidavit in support of that. You can also file an affidavit in support of an application or in response to an application about a priority parenting matter. And so a priority parenting matter, just briefly, would be for more urgent issues like having to apply for a passport or having to apply for an order allowing you to travel. There's other different categories of what is considered a priority parenting matter. We're not going to go over that today, but just for the purposes of this presentation, these are what some examples of what an affidavit can be used for. I have a note here that affidavits are not necessarily required because a hearing is typically going to be scheduled for enforcement and priority parenting matters, and the parties are going to provide oral evidence. So sometimes people want to file affidavits just because it provides the court with further information, and it's easier maybe to get facts down on paper rather than leaving it all to a hearing where you're going to have to provide oral evidence. But sometimes there isn't a lot of time either. Like you might be filing an application for a priority parenting matter or enforcement, and you might get a court date within 7 days or 10 days. And I just say that don't feel the pressure to file an affidavit because you will have an opportunity to give oral evidence. But some people find it very helpful to have it filed in advance, just so that, especially if there are a lot of facts and a long history, that it's all documented for the court. And sometimes or often the judges will have an opportunity to read that before the hearing and get a sense of what the issues are. For family management conference, so this is typically the first court appearance after someone files an application about a family law matter. So for not an urgent issue, if you're applying for an order for parenting time or contact time or child support, and you get a family management conference date, you can file an affidavit. In my practice, I often don't, but sometimes in some situations I do. So there's no requirement that you have to or don't have to. I just have a note here that some clients think that, okay, if I file this affidavit, the court's going to read it and they're going to make a decision at the family management conference based on this evidence. That's not necessarily true. You might, get a judge referred to your family management conference right before it starts, and they might not have, had the opportunity to look at the entire court file or read affidavits, especially if they're extensive. So I always caution my clients that yes, we can prepare an affidavit for a family management conference, but just because we are able to and file it and serve it doesn't necessarily mean that the court will be able to rely on it at the FMC. And then I also have a note that they're typically not used at trial. So if a trial is scheduled or even a hearing on these issues, the courts typically want to hear from the parties, testifying in person so that they can be cross-examined. So I just note that they're typically not used at trial, but it'll still, if it's filed, before trial, it's still going to form the court file and the judge would have reviewed that, but you're typically expected to give oral evidence at trial. Okay. We'll move on to the next. Okay, and I just have a note here that if you're applying or responding to an application for a protection order, there's actually a separate form. So you'll still need to, applying for a protection order, you'll still have to prepare an affidavit. And the form is an F12, and it's actually an application and affidavit in one. You'll see that these affidavits on the provincial court website are different from the Form 45 general affidavit. And so the protection order affidavit, we're not going to go over it today, but there are very specific questions on that application that form the contents of the protection order affidavit. So it is a separate affidavit from the general. And then there's also a separate affidavit if you are applying to become a guardian of a child or children. And so that, just for your reference, is Form 5. So again, there's very specific requirements and specific information required in a guardianship affidavit. So you'll want to make sure that if you're required to file one of those two other affidavits, you're not using the Form 45. You don't want to spend all that time and then have to redo it and put it into a different format. And I've included the link for where these two other affidavits can be found at on the provincial court website. Okay, so I've taken these bullet points, just paraphrased them from the instruction form right on the affidavit. And so I'll just explain what these mean. So the affidavit must be written in first person. And what I mean by that is, I, Nicole, am the mother of the child, right? I'm saying I am. So you're writing it like you're telling your story to someone else, okay? You really want to stick to the facts, okay? They have to include facts. It's not, um, you shouldn't include speculation or, um, your views necessarily. It's really just sticking to the facts and as much as possible. If the information is not firsthand, so if you heard something from someone else, you have to explain to the court how you got that information, how you became aware of that. And I'll just remind you that one of the in that first page of the affidavit, when you're saying, I know or believe the following facts to be true, and if these facts are based on information from others, so secondhand knowledge, I believe that information to be true. Okay. You're also, so I have added this blurb here, and this is very standard, so you can feel free to use it in the affidavit, but basically it's just expanding on what I had just read from that first page of the affidavit. I am the applicant or respondent in this matter, and as such have personal knowledge of the facts and matters deposed to, except where the same are stated to be made on information belief, and where so stated, I believe the same to be true. So just a lot of words for what I had said earlier on that first page of the affidavit. You're going to include relevant information to the application and then the orders that are being sought. You can also attach what are called exhibits. So exhibits are after you're done writing or after I guess the document, the affidavit with all the facts, you can attach exhibits to the end of the affidavit, but that's also going to form part of your affidavit. The whole thing is your affidavit. And these exhibits or attachments can include text messages between the parties, documents, photographs, but importantly, not intimate images. I can move on to the next slide, please. And then more rules. The affidavit length, so the whole affidavit, first page to last page, signature page, cannot be more than 25 pages, and that includes exhibits, right? So if you're attaching messages or photographs, all of that forms your affidavit, and it cannot be more than 25 pages. The affidavits have to be in printed form, so you can't use any electronic documents, so no USB, video, or audio. And then you have to include page numbers in the body of the affidavit and exhibits for ease of reference, because if you're in court and you're going through the affidavit and you want to bring the court's attention to a particular paragraph or a page or an exhibit, you want to be able to refer to those easily. So you would say, okay, Your Honor, on page 8, that's paragraph 40 of my affidavit. So everyone will turn to that page and find that paragraph number. Also really important to number the exhibit. So, okay, exhibit A, which is on page, 24 of my affidavit. So everyone can find that easily. The paragraphs should be numbered consecutively. So remember in the first page, they gave you one line to do paragraph 2, 3, 4. Each paragraph, again, because you want to be able to refer to that easily and the judge needs to be able to find it easily, everything should be numbered consecutively, 1 through 4, etc. Okay. Okay, so then we're going to get into drafting tips. Essentially, you're going to you're telling a story, you're telling your story, right? And you're presuming that the person reading the affidavit doesn't know anything about your file, your case. And so it's really a fine balance between okay, providing relevant information about recent events, but also enough background information so that they have context, right? And why you're here now, why you're responding to or making this application. And it's really important to, what I say here in the first bullet, detail relevant events in chronological order as much as possible. You'll also want to consider using litigation background, procedural history. And what I mean by that is maybe some brief paragraphs about the current application before the court was filed on X date. And in that application, I'm seeking the following orders, right? Or the other party applied for the following orders in this application, and my position is just some context for, again, why are we here? And don't get too caught up in like providing really detailed litigation background, especially if you're self-represented, because as I said earlier, presume that someone doesn't know, why you're here and you're providing this information for the first time. The judge will also be able to look at the court file and get a sense of what's happening and what the current issues are. You're going to use present tense, so what's currently happening. I say use simple language. A really important tip is using headings by topic. It's really helpful and it helps the judge and the reader. And I suggest grouping the evidence by subject. So an example could be, okay, the current parenting arrangement. So that's a topic, right? And you would say, since X date or since this order, this is the parenting time schedule. And so under that heading, it's going to be just what the current schedule is. Okay. And then moving on to a new topic, you would do a new heading, just so it's easy for the reader to know, I guess, what the subjects are and also be able to refer to them easily. And also while you're going through the affidavit for ease of your reference. On the right-hand side, more tips, avoid hearsay. So hearsay is information that you don't have firsthand, that you have from someone else. So an example could be, my friend told me that, right? Well, my friend told me that my ex said this. You didn't hear it firsthand from your ex, you're hearing it from your friend. So that's hearsay. And so you really want to, as much as possible, steer clear of that and focus on what you know, because with the affidavit, that person that you're taking evidence from, that hearsay evidence, they're not the ones swearing that this is true. And so the court is in a position where it can't really test that evidence, and the court might decide to give that hearsay evidence little weight, meaning, or no weight. They could say, okay, we can't really rely on it. We don't have a way of verifying whether or not that happened. And so too much hearsay can really detract from the evidence that you have firsthand knowledge of. So try to avoid that as much as possible. I say to address the facts head on, really stick to the facts, refrain from opinions. So, if you're in an affidavit, you're not really being asked to give your opinion on whether or not these parenting arrangements are in the best interest of the child. You could say, from my perspective, it is, but a lot of times opinion is really going to be reserved for experts and expert evidence. You're also going to want to refrain from emotion or speculating. Again, just coming to conclusions without having the knowledge or evidence to do that. Your affidavit shouldn't contain argument. So you don't want to get into arguments with the other party responding to an affidavit. Arguments should be left for court. When you're trying to convince a judge what orders should be made and why, save that for court. Your affidavit is really just to focus on the facts. Similarly to the headings tip, each paragraph should deal with a particular topic. So you really want to avoid big blocks of text. I think it's difficult for the judge to read, and there might be some really important information that might get lost in a big block of text. So really try to stick to shorter paragraphs, like, no more than a few sentences. And if it's a new topic or new subject, break it into different paragraphs. Okay, more tips on the next page. Okay, when you're responding to an affidavit, so if you've been served with an affidavit and now you have to respond to what the other party has said or is saying in the affidavit, my suggestion is to be brief. Focus on what is inaccurate. So if there is something in that affidavit you're responding to that you have a different version of, or that's not how it happened, and you can show that that's how it didn't happen, focus on that. Okay. There's a lot that might be true. So in the beginning part of the affidavit, where they're saying, oh, here's the procedural history, or here's what the history of care has been. There may not be too much discrepancy with that. So really focus on what is inaccurate from your perspective. I see here where there is a different version of events or you're responding to an allegation. And you can use this language in your affidavit. This is standard. We use this. You can state, I deny every allegation unless explicitly admitted if you can't respond to every statement. So sometimes, well, it's not uncommon to get affidavits where there are so many paragraphs and there are so many allegations. And again, you don't want to get into this back and forth, this argument. And so this is a, a statement that you can basically include to say, like, even if I'm not responding to every single thing, like I'm denying these allegations, okay, because it just might not be possible, especially with the page number constraint, to be able to respond. But again, if you do have a different version of events, do try to respond to that with my first point. Focus on what is inaccurate or what you have a different perspective on. Okay, so the jura, so there's that word again, the signature line, should appear on a page with at least one paragraph of the affidavit. So this goes back to what I said earlier. We want to make sure that whoever is reviewing the affidavit knows that every page in the affidavit was presented to the commissioner or notary or lawyer, and that the whole thing was sworn as being true. And so what we want to do, because the numbers are going to be in consecutive order, like 1 through 20, for example, we want to make sure that that signature line, that signature page includes the last paragraph at least or more. And so you want to make sure that there's no discrepancy and it doesn't look like, oh, okay, someone just added the signature page at the very end and maybe some after some paragraphs or pages got added in before the signature page. You just want to make sure that it's very clear that this whole affidavit was sworn before the commissioner. Okay, it also says fit information into one affidavit, as there may not be sufficient time to review multiple affidavits and to cross-reference. So we really want to avoid a battle of affidavits, especially if you're doing this in preparation of a family management conference where the courts only have 45 minutes for family management conference. And there might not be, even in a hearing, if you have a half-day hearing, the court might not have enough time to review an affidavit and then a responding affidavit and then a responding affidavit to that affidavit. And it's going to be really challenging for the person reviewing the affidavits to keep cross-referencing from one affidavit to another. So really, again, you're going to try to make them succinct if you are using affidavits so that you don't have to have multiple affidavits. Again, stick to the issues. I'm just repeating myself here, avoid repetitive, identical affidavits. Also avoid absolute, so never, always. So this is just language I always try to steer clear of, because a lot of things are not never, right? Or always. Like, you just want to make sure that you're not using any exaggeration or generalization, because it could take away from the overall credibility of the affidavit. So just keep in mind that kind of language and look at it in terms of how would a judge be reading this. Is it true that he never does this or that he always does this? You just want to be cautious of that kind of wording. Okay. Exhibits. So again, these are documents that you can attach to the affidavit that form part of the whole affidavit. Again, I went over some examples. Text messages. So we're seeing now, like a lot of people are communicating in writing, so email or text message, and it's great because there's a record of it in court, and quite often having written communications keeps parties in line in terms of how they communicate with one another, because they know that the other person can use them in court. I have a tip, like just ensuring that the dates are included in the text messages. So, I mean, depending on what kind of phone you have, it may not be possible to have dates and everything, but as much as possible, try to include the date. So the month, day, year. And there are apps that you can use that will actually like download all of the messages and have the dates. And you don't want to use too many. Again, like you have 25. Oh, you only have 25 pages in your affidavit. So you really want to be selective about what messages you're using. It's not really helpful to use, in my opinion, messages from years and years ago. You really want to stick to uh, probably what's more recent and relevant. Again, you can use photographs, but just the caution about not using any intimate photographs. You might use receipts if financial, so Section 7 expenses are at issue. So earlier when we were talking about the financial statement and having proof of what those expenses are, like daycare receipts, for example, the affidavit might be where you attach those receipts. And just a note that if you're referring to, or if you're attaching documents as an exhibit, so with the text messages, let's just say you have messages spanning a few days or weeks, you don't have to mark each text message as a separate exhibit. That can be quite cumbersome. So you can actually just mark all of the text messages or a collection of pictures collectively as exhibit A or B. Also, you use letters when you're referring to exhibits. So exhibit A, exhibit B, exhibit C, and the person who is helping you swear your affidavit will ensure that all of your exhibits are properly marked. Okay, so again, it's easy for the judge to refer to. I also say like do not attach documents already in the court file. So again, the judge is going to be able to review the court file and see what court applications and replies and financial statements, et cetera, orders are in the court file. So you don't necessarily have to attach those, or you shouldn't attach those to the affidavit because you will probably go over your page limit. Okay. All right, so just some more tips about text messages and emails as exhibits. So again, it's not overly helpful to have ton of text messages because there might be some really important ones that get lost in just the amount of text messages. So there's a risk that they may not be read, or that the really important ones kind of get buried. So I always say quality, not quantity. And then if there's an important text message or email that you really want the court to pay attention to, in the actual body of the affidavit, so in your numbered paragraphs, you can state, what happened and why it's important. So you can say, paragraph 20, on this date, have the date, the other party sent me a message that said da da da, and you can paraphrase it or put, exactly what was said. And attached as exhibit A to my affidavit is a true copy of that text message, right? So it's referred to in both. You do want to provide context in the body of your affidavit, because just attaching the text messages and may not be helpful if the court doesn't know, like, okay, well, why are you including this, or why was this significant? Essentially, the purpose of any exhibit you're attaching is to corroborate or back up what you're stating in your affidavit. Yeah. All right. Okay, so here's that word again, credibility. So just as a financial statement, an affidavit is a sworn statement of your evidence. You have to think of it as the same as testifying in court. It becomes part of the permanent court record. So there is no difference whether you're writing this in affidavit or saying it orally in court. Once you're swearing it's true on the affidavit and filing it, it is part of the court record. And you can also be cross-examined on the affidavit. And, let's just say you're preparing an affidavit for a family management conference. That affidavit, once it's filed, it's part of the court file and it can be used later on at trial. So, you just have to be cautious of that, right? That eventually, like if you go to trial, the other party can cross-examine you on any of the contents of your affidavit. So to avoid any issues about credibility, it's really important to be aware of any inconsistencies in your evidence and not to misrepresent facts. really take care about the facts. They have to, the affidavit has to be truthful. And, even if something is misrepresented inadvertently, like it's not done on purpose, just the fact that it was misrepresented could raise issues about credibility. And that might not be fair, but that's why it's really important to be very cautious about what you're writing. It has to be true. A consequence is that the court may not end up believing the person's evidence, and it could affect the case in a negative way. So really, really be careful about what you're swearing to be true. Okay. To the next slide, thank you. Okay, how to file and serve affidavits. So again, you have to meet with a commissioner for taking affidavits and sign the document in front of them. So again, you can go to the court registry or one of the resources that Jennifer explained after the break. All exhibits, so just like the financial statement where we had to attach the income tax returns and the pay statements and everything as one document. Similarly, the affidavit, all the exhibits have to be attached to the affidavit when swearing. So you're going to take your affidavit with the numbered paragraphs and all of the text messages and whatever else, as long as it's 125 pages, take that to the commissioner and they're going to make sure that each exhibit is properly stamped and marked. They have an exhibit stamp and they will sign it, each exhibit. Again, it can be done at the court registry. And similar to the financial statement, so that Rule 172, it allows an unsworn document, so an affidavit, to be filed if you're available to swear or affirm the contents of the document are true during the court appearance. Again, and in practice, it's best to have it sworn beforehand, but it is possible based on this rule to file an unsworn document. Okay. Affidavits and service. Okay. So this is as much as possible, the general rule is you want to have the affidavit sworn, filed, and served with as much notice to the other side as possible. Okay. So if you're filing an application about enforcement or an application about a priority parenting matter, and you're filing an affidavit in support of one of these applications or in response to an application, in practice, you should file and serve the affidavit together with the application, right? So if you're filing, let's just say, an application to enforce an order, ideally you'd file the affidavit at the same time. And I also just note here that an affidavit's not required because, again, you can provide oral evidence at the hearing. So sometimes, especially if you're dealing with an urgent issue, such as trying to enforce an order that the other side is breaching, you may not have time to do a detailed affidavit. And so I can't give you specific advice about your particular case and what strategically might be best, but I just say that in the interest of time and because you might be dealing with an urgent situation, sometimes getting the application in and getting a court date is the most important thing. And the affidavit can maybe come later or might not be required at all because you might be able to just give oral evidence, or you will be able to give oral evidence at the hearing. Family management conference. So this is for the less urgent issues. So my example earlier about, someone has applied for parenting arrangements or contact time or child support or any of the above, and you're scheduling a family management conference, in 1 or 2 months in the future. There is no timeline for service under the rules, and you might hear different directions from different registries about when it should be filed and served. In practice, in my practice, I would say at a minimum, you want to make sure you serve any affidavits at least 7 days before the family management conference for 2 reasons. You want to make sure that, the judge will have sufficient time to read it. But again, there is no guarantee because just depending on scheduling, they might assign a judge to that case right before the FMC. So there's no guarantee that the affidavit will be reviewed, just to keep that in mind. But also for the other side, it's important to give them an opportunity to review the affidavit beforehand, especially if you're asking the court at the FMC to possibly make orders that you're asking for and rely on the affidavit. affidavit material, the more advance notice you can give the other side so that they're not caught off guard or feeling ambushed, the better. So again, there's no specific rule, but I would say in practice, it's best to give at least 7 days notice. And then how you serve the affidavit can be served by ordinary service to the address of service for each party on the court file. Okay, and so I have, so I don't know how we want to do this. I just came up with some examples about, or, statements that would go in an affidavit. But there are issues with each statement. And so, with each statement, I'd ask you to identify what the issue or issues are with the statement and how you might improve the statement with some of the tips that I had gone over previously. So Jennifer, I'm not sure if this is a part where we can maybe take some questions about affidavits or maybe open it up to people in terms and
Yeah. So we have quite a few questions actually.
uh-oh.
So I'll try to get through them.
And I can also just with these 8 examples, I can go over how I would change it. So if in the interest of time, it might be quicker if I just say, okay, here's what the issue is and here's how I would change it. Maybe we can start with some of the questions.
Okay. So this one was about going back earlier to, how to set up your affidavit. So how you said that they don't give you that much space.
Yeah.
They were asking, is it better to use the form and attach extra pages or use a fresh document and format according to the form?
Yeah, it's really a matter of preference. What I do is I have just a Word document and I have a template basically. I've copied exactly like what the PDF form says. And then that way I can put in as many paragraphs as I want and then have that signature portion, the jurat at the very end. I'm just gonna check like the actual PDF form to see if there's a way to just add in the paragraphs on the PDF. I didn't think so, but yeah, maybe while we're going over the next question, I'll just have a look at the form, the PDF form and see. Okay.
So this person's just asking about length for 25 pages. So for affidavit length of 25 pages, is it 25 physical pages back and front of a page? Or is it one page as in one side? So like, do they count double-sided or just one side?
So just one-sided. So anything that you're filing for, and that's a great question. Everything should be one-sided. So you're not going to print double because the court, they'll scan in the documents and there's an electronic file. And once, if you're serving them by email or they're being sent to the other party by the registry, everything's just single-sided. So you want to make sure that it's 25 pages, like physical pages, but only on one side. Okay, not double-sided. And I also should note, like, I would use at least like 11 or 12 font. You don't want to make the font too small just to make sure everything fits in 25 pages or less, because it could be really hard for the judge to read or the other side. You want to make sure it's legible and that you're not adjusting the margins too much. And yeah, like, I think depending on how many exhibits you're using. I haven't had too many issues keeping everything under 25 because if you really focus on, okay, I need to make this distinct. I really need to focus on the most relevant issues in the current application before the court. You should be able to get it all in within 25 pages. And you don't want it to be too long either, because as I said, there might be some really important information and facts that could get lost in these pages and pages of documents. So you really want to focus on the quality of the exhibits over the quantity and sticking to the most relevant facts to your case. And just to follow up on the PDF form, so I can't add in additional, you might be able to figure it out in the PDF, but I can't add in additional paragraphs on the actual PDF. Yeah, so I've just used Microsoft Word, just done one document and added in my paragraphs that way. I should
Could
note,
you do
yeah.
like under paragraph, like next to paragraph 2, see attached Word document or see enclosed? I know I've seen that a couple times.
You could, as long, so I would just call, like, so that's a great way to do it, because then you don't have to format that whole PDF onto like a separate Word document. But I would just make sure that if you're doing that, that it's very clear that the signature page is on the last page of the additional documents, right? Because it could be confusing, right? When you look at the affidavit, like, okay, the PDF, I can just sign the signature page here. And then if I say see attached, see attached pages, but there's no signature page on those attached pages, you just don't want any situation where there could be confusion about what was sworn and what was not. So it's just best practice to have that signature page at the very end of the documents. And just to touch on the 25 pages limit. So you can apply, if you really can't get it done in 25 pages, you can apply to court using an application for case management order without notice for permission to file an affidavit longer than 25 pages. And this is taken right from the instruction page of the PDF form that you can access online. So they have a list here of formatting requirements, again, divided into numbered paragraphs, page numbers, not longer than 25 pages, including exhibits, unless you have permission from the court to have a longer affidavit. So I've never had to apply. I think as long as it's not over, like way over 25 pages, 50, 75, there's a possibility the court will allow you to file the longer affidavit. But again, like, just keep in mind that you want it to be succinct and really quality over quantity. And then the last formatting requirement, as I said, contain at least one paragraph of the text above the jurat, the signature portion, and have the jurat all on one page. So again, the court wants it to be very clear too that, the whole affidavit is being sworn, and that's why the jurat, the signature line, appears at the very end.
So we do have quite a few questions. So I'm actually gonna funnel through some of them. So anything related to Supreme Court, just because I'm noticing the time. Anything Supreme Court related, unfortunately, we're not answering that because we're focusing on provincial court. And anything to deal with someone's case specifically, we're not going to be touching on that, even trying to generalize anything. So I guess one person just asked about, you'd mentioned litigation background. So they were wondering, what do you mean by that? Like, because they have litigation background case law question mark. So I'm guessing it's just more about like the history of your case, date you opened or date you submitted your application, date you replied, any court hearings or orders, like just
Exactly. Yeah, perfectly summarized. So, for example, I started these court proceedings in 2018. This is the current court order, right, made on X date. So you're not providing like every single thing that happened in the court file. Really, like, stick to what are the current orders, maybe when did these proceedings commence. And again, the judge is going to have access to the court file and can have a look. And by the time you're in court, some of these files are really thick. You're not expected to go over a very detailed litigation history, because that's there for the court to see if needed. You're really focusing on, when did I start these proceedings? What are the current applications before the court? So I filed the application about a family law matter on X date. The other party filed a reply. This is the current court order, and this is what each of us are seeking. That's all it has to be, just no more than a few paragraphs.
And if someone witnessed an incident, can you mention it in your affidavit, or would that still be hearsay?
So if you didn't witness it yourself, it would be hearsay. Again, I can't give advice about whether or not you should put that in. It really depends on, is there another way to get that evidence before the court? Can that person swear an affidavit, right? That's the ideal, right? Like, if that person can do their own affidavit, the person who witnessed it, swear their own brief affidavit, or come to court as a witness, that's the ideal. For the court, because then they're not relying or having to consider hearsay evidence. So just generally speaking, like, you could include that, but it's hearsay evidence, and there are limits to how much weight, how much consideration the court is going to give that. The court could decide to give it little to no weight. So that's something that you would have to get advice on about whether or not to include it. But always ask, is there a better way to get this evidence before the court? Because the rule is best evidence, right? So the best evidence would be that person either coming to court to give direct evidence of what they witnessed, or swearing an affidavit about what they witnessed directly.
For exhibits, there's one, they're asking, must exhibits only be lettered? I.e. not acceptable to have them numbered. So, like exhibit A, B, C, D.
So they should be lettered A, B, C, D. Sometimes there are a lot of exhibits. I don't know if this would apply because of the page limit, 25 page limit, but in really extensive affidavits, sometimes the exhibits go beyond Z. And so you might have to do like AA, BB, CC, but probably not going to happen, especially if, as I said earlier, you can group similar affidavits and mark them collectively as one exhibit. So if there are a series of text messages that you want to attach, you could attach all of those text messages as one exhibit, as exhibit A, and then just make sure that each text message, each page is numbered, right? As part of the affidavit. So yeah, you probably won't have to go beyond Z for a provincial court affidavit, but they should all be lettered.
If text message or emails used for evidence isn't in English, would the one party or would that party's translation be honored by the court, or do they have to hire a professional translator?
Yeah. So again, best evidence would be getting the message or email translated by someone who is court certified, but that takes time, right? So I have used messages where my client will say, okay, here's what the translation is. But the caution with that is I don't speak the language. And so I relying on my client's translation, and it may not be exactly like, inadvertently, it might not be an exact translation, it might be paraphrased. So the best practice is to have that translated by a court certified translator. And again, you'd have to just decide, okay, do I use that in an affidavit, or should I use that text message later on as an exhibit at a trial where I have more time to have it translated for the court? Because you just don't want to run into any issues where there's later on like, okay, that wasn't actually what was said. And again, the court, I think it'd be, they could maybe say, okay, well, for the purposes of this is what this person's saying is their evidence. This is a translation, but the court can't really be sure unless it's properly, court certified translator. So that's just best practice. But yes, I have done that where clients will just translate it themselves. But the best practice is to have a court certified translator.
Got a lot of questions happening and I just lost my spot.
Part two.
I mean, we could go over a little bit, like if that's okay with you, like another 5 or
Sure,
10
yeah.
minutes. Just because, yeah, we have a lot of questions right now. Where was I? Lettered. So with this one, I'm not sure if you can answer this. What happens if you know the other party has lied? Would you bring this up if it goes to a court hearing or trial? So like I guess if they lied in their affidavit, would you bring that up in court, or how would you what is best practices, I guess?
Yeah, so when you're responding to an affidavit, so when I earlier, one of the tips was focus on any inaccuracies, misrepresentations. I'd steer clear of like language if you're responding to an affidavit, like paragraph 5 of the other party's affidavit is a lie. Rather than stating that it's a lie, give your version of events, but also know that eventually, like if you do have a trial or a hearing, you will get to cross-examine that person on their affidavit and highlight any inconsistencies. And if, for example, the lie is the applicant didn't offer any parenting time on Christmas for me this last year. And that's a lie because you have a text message where you're offering parenting time on Christmas. You can attach that text message to your affidavit and say, in response to paragraph 5 of the other party's affidavit, I did offer Christmas parenting time. See attached exhibit A. And so you don't have to say that that was a lie, but the exhibit and what you're attaching speaks for itself. So you will have an opportunity to respond in an affidavit and or cross-examine the other party on the inconsistency or the misrepresentation, but I would just be cautious of the language I'm using because, if you have text message proof that what they're saying is not true, like that's sufficient without you having to say, oh, they lied about it.
So this is about service. So is email confirmation of service from the other party instead of serving by a regular mail acceptable to the court? So I guess if you serve someone by email, if they respond back saying, got it, that deemed acceptable by the court?
It depends on what their address of service says. So, so basically, when you have a court file, the address for service is any document that you filed indicating what your address is. So you'll have a physical address. Often these days, especially, people will include an email address. And so if you serve, and what we say by ordinary service, if you serve the affidavit or financial statement by ordinary service, it has to be to the address of service. So if they've included an email address as an address for service, again, which most parties are these days, just because of the times we're living in, email is sufficient because it's part of the address for service. And you should file a certificate of service, just attaching. So the certificate of service can be found on the Provincial Court Forms website, but you're going to be just attaching a copy of your email and the copy of the documents that you attach to that email to the certificate of service to show that it was served on X date by email. But just ensure that if there is no email address for service, so if it's just a physical address, it has to be sent to the physical address. And I would recommend registered mail so that there is proof that you sent it.
All right. So for this one, I will just say quickly with this question, the 25-page rule is provincial court only, Supreme Court, different rules. So I'll go ahead and then ask, because they did ask a couple times about Supreme Court. 25-page is just for the affidavit. How about exhibits? Do we have a limitation or should it be inclusive 25 pages?
All in. So the whole, your affidavit is the body, like all the paragraphs, the body of your affidavit, and all exhibits. So your whole affidavit cannot be more than 25 pages in provincial court. Again, if you're over, you can apply to court for permission to file an affidavit over 25 pages. But if you don't do that and you don't get the court order, the registry will not accept it. It has to be 25 or less. And that's first page to last page. So the first page that I showed you and the signature page, all of that, and the exhibit, sorry, all of that has to be under 25 or less.
Okay. So for this one, I think it's already tied into it. So they're like, if you max to 25 pages, you have to apply to a court, or can you do supplementary?
Like breaking it up into 2 affidavits. So again, my tip is that, you want to avoid multiple affidavits because it's difficult on the person reading it. So the judge to cross-reference, right, between multiple affidavits. And then it makes it really cumbersome too when the other party is responding to an affidavit, they're responding to one and then another. It's just, again, best practice to do it in one affidavit. And if you really can't stick to that 25 or less limit, to apply to court to get an order allowing you to file an affidavit over 25 pages. But it just really becomes challenging when there are a lot of affidavit and really confusing too. And especially if there isn't a whole lot of time to review the affidavits before the court date, whether it's a family management conference or a hearing about enforcement. The last thing you want is to to have to refer to multiple affidavits, and it makes it really hard in court too, right? It can be really confusing. You want to just have, if you're going to use it, one affidavit with all of your evidence.
So just touching on some people who are asking about affidavits and hearings. We are going to be touching on trials and hearings next week. So we can bring up some of those questions again next week about using affidavits for hearings, written submissions. How does that work? So we'll touch on that in more detail next week, just so that we can appreciate the time right now. So another question is, if I have picture evidence, would it be better to show, for, I guess, for family violence, if there's picture evidence to show certain things, is that okay to include?
Yeah, the caution is just no intimate photographs, but definitely, and this would be for the protection order affidavit specifically, but also, in the general affidavit, if you're not applying for a protection order, but still need to bring up, instances or past incidents of family violence, then for sure you'd want to attach those as exhibits. In the body of the affidavit, because many pictures these days, I don't know how to do it, but probably won't show the timestamp. Like you might be able to figure out how to have the timestamp on the actual picture. But if you don't or can't, then make sure the body of the paragraph indicates when you took that picture, right? So you'll have to look on your phone and see, but definitely those are, as long as it's printed. So I said earlier, nothing digital. It has to be printed on a piece of paper and attached as the exhibit to the affidavit.
Okay. So this one's a interesting question. So it's about moving a provincial court file to Supreme Court. So what happens with affidavit evidence that you filed in provincial court? Does it get moved to, like, would they move the whole physical file to Supreme Court? I don't know if you've come across that before. I know it's not really a common thing to move from one type of court to another.
I'm dealing with it in one of my cases. Like it hasn't been transferred yet. I don't know if it will be, but um, that's a really good question that I don't have the answer to. I'm presuming the whole file would, like like the contents of the whole file, like all the affidavits. But procedurally, I'm just not sure. Like there could be, yeah. I don't want to give an incorrect or misleading yeah, answer, but in my view, everything should be, right? If you're transferring it for all purposes, even from registry to registry, if you're asking for, a court file to be transferred from Victoria to Vancouver, for example, in provincial court, the whole file is transferred. But I'm just not entirely sure about provincial to Supreme. Presumably everything is also transferred, but can't be 100% sure.
Yeah. Okay, so for any questions, again, anything really related to Supreme Court, unfortunately, we can't touch on because we're only dealing with provincial court. And for anything that's asking about using, your affidavit evidence or submissions or anything like that for trials and hearings, I would write those questions down. You can go ahead and submit them to us this week at info@litigantschoolbc.com. And my co-chair, who will be on next week, I can bring those questions to her attention, that hopefully it can be touched on during next week's segment, which is trials and hearings. Or you can just hold on to those questions until next week, and then we'll try to answer them there. So thank you so much, Nicole. This was so helpful, like just breaking down all the steps for financial statements and affidavits, because it is confusing and provincial court is a little bit restricting in some ways. So it's nice to know these tips about how to organize your thoughts, how to present, what you want to present, when it's appropriate, not appropriate, and just breaking down like how one fills out a financial statement. Because I know for me personally, if any of you guys have seen those forms, it's a lot of information, like a lot. Like the instruction sheet,
Yeah, and
like you gotta read them in like a novel, right? You gotta take breaks. So
yeah.
breaking it down is so helpful. And I know that there was some fun, like a fun little activity here. So when we circulate, I don't know if you're okay with this, Nicole, but when we circulate this, if people want to just try to,
Sure.
you know, um, see if they can figure out what's wrong with each of these paragraphs and then rewrite it. Like, would it be okay to share with you?
Sure, yeah, and I can give my feedback ungraded. It's open book. But yeah, and I'm sorry we just ran out of time, but yeah, it's just I think it's, you know, we're talking about the tips, and you know, some of them just might seem abstract, but when I have these examples, you can really see how the tips are important and how it really improves the statement. And yeah, these are just some examples based on what I've seen in affidavits, you know, even from some lawyers, right? So we can always, even as lawyers, can work on our affidavit drafting and in writing. And so certainly go over the questions on your time, or the statements on your own time, and take a stab at it. Yeah, I'm sure that folks will have some good suggestions that I might not even have thought of. But
All
yeah,
right.
thank you so much for having me. And as I said earlier, I commend everyone for sitting through this. I know they might be kind of dry topics, but I hope I reiterated how important these documents are for court, and just the importance of not just, you know, for the time being, but in the later on proceedings, right, how they can really have an impact on the case. And so really taking the time to draft them properly, to get the information and advice that you can get early on when drafting and preparing them, it's really essential. So yeah, thank you everyone for sitting through this.
All right. Okay, everybody, have a good night. So for the recordings, as I've mentioned, we are doing it more towards the end of all these sessions. But we will circulate the PowerPoint slides, and I do understand, I think week 4 was not circulated, so I'll make sure that gets circulated ASAP. And same with any materials shared tonight, we'll circulate those in quicker time. And we'll see everybody next week for trials and hearings. And have a good night, everybody.
Good night, everyone. Thank you. Thanks, Jennifer.
Thank you. All right. So